and good morning, everybody, and welcome to episode 4 of our third Tuesday webinar. Today's topic is about FMLA, and this comes as a specific response to many requests that we've received through our survey that we send out after our presentations. Many of you had asked for FMLA, and quite a few have asked for us to get really deep into FMLA, and so we are going to do that. So we're going to be doing this as a 3-part series, and this is, of course, part 1. And we're going to cover who is covered as far as a covered employer. We will be talking about employee eligibility, and then we'll be discussing notice requirements. For those of you that are familiar with FMLA, you'll realize that this is a very narrow slice of the FMLA, and in order for us to do a deep dive, I did have to kind of break this up into pretty small chunks, so we may even have a 4th part depending on how much I'm able to get through in each of the 3 parts coming up. So just an FYI, this is the first part talking about employer coverage, eligibility, and notice. My name is Janelle Stanton. For those that have been in our third Tuesday webinar previously, thank you so much for being in attendance again today. And I'm the Director of Communications here at myHRcounsel, so one of my main roles is education and doing these types of presentations. For those of you that are new, we do these every third Tuesday, just like the name sounds, at 11 o'clock Central Time. So we'll be touching on an HR-related topic each month going forward. We had discussed the idea of doing a business topic. Unfortunately, we will be doing that as a separate one, but we are going to focus all of the third Tuesday webinar series on an HR-related topic. If anybody has any business-related contracting, construction, collection, any type of business-related content they would like us to present on, please let us know that. We'd be happy to create a webinar based on what everybody in attendance would like to see. So as far as the agenda today, we are going to be talking about, I forgot to update this, my apologies. We obviously talked about handbooks last month. We're going to be talking about, again, the notice procedures. We will talk about record keeping, who for employers is covered, and getting into all of that. As far as some housekeeping items, we did receive a piece of feedback about providing the slide deck in advance of the presentation. So if you click on the handouts link, you'll notice there's a handout listed there. That is a PDF version of the presentation today. So if you want to pull that up and quick print that out so that you have it to take notes on, that is available in the handouts section there. We do always record our presentations and send those recordings out in case there's anybody that, in your office that you may want to have listen to this. In case you need to jump off for any reason, we will record this and send this out. But just know that you do have to be present for the entire presentation in order to be able to get the HRCI credit code. And again, these emails, it depends on how long it takes me to put together a Q&A and things, so it may come out tomorrow or the day following. So in the next couple of days, look for your credit. Everybody that attends will receive that via email. So we had some questions last time about where was the credit. It does take some time for the presentation to download and for me to put some things together. So if you're not seeing that today or tomorrow, please know that sometimes it does take a couple of days for things to get downloaded as far as the presentation recording. In addition to the HRCI credit, I always send out typed out Q&A. So there is a space where you can enter any questions that you have. If the questions are relevant to the topic I'm currently discussing, I'll address it right away. Otherwise, we do have time at the end for some Q&A. I always type that up and provide that to everybody in attendance as well. And then you're also going to receive a brief survey, which I already mentioned. please fill that out. It's very short and it just lets us know how we're doing. And then again, if there's any topics that you would like us to present on, every topic that we've presented on since exempt, non-exempt was in response to a survey question asking for that material. So just please do fill that out if you have a chance. And then also I will be sending out a FMLA decision tree that we in-house here had made. So everybody in attendance will receive a copy of our FMLA decision tree as well. Okay, so jumping right into the material, we've got a lot to cover here. So like I said, we are going into the weeds and getting very high-level detail here. So if there's questions or confusions, please ask those anytime you have them. So Family and Medical Leave Act, the FMLA, it was passed back in 1993. It actually had been proposed to the legislature many times in the 9 years prior to 1993 and had been vetoed by George H.W. Bush. And they continued, and the groups that were interested in passing it finally were able to garner enough bipartisan support to get that signed into law by President Clinton in 1993. Its original purpose was to balance the demands of the workplace with the needs of families. And so originally, FMLA entitled employees to take a reasonable leave for medical reasons, the birth or adoption of a child, or for the care of a child, spouse, or parent with a serious health condition. Now, most of that's going to still sound familiar, but that has, since its original passage, the scope of FMLA has been amended and expanded to also cover various types of military leave as well. So there have been changes that have been made to the FMLA since it was first enacted. There has been tons of regulations written to address that. There have also been other case law and things that have sort of given more shape to FMLA as well. So throughout the years since this was enacted, it has been modified. And today, FMLA has a very prominent role in the workplace. And I would say that FMLA is probably one of the top 5 legal questions we get from our clients every day. This is a seemingly straightforward rule, and you can see from my generally statement there, it's seemingly straightforward, but as we get into the weeds on this, you'll notice there are a lot of little tiny nitpicky details that an employer has to pay attention to with this law. So generally, FMLA requires a covered employer to grant an eligible employee with job protected leave for a qualifying family or medical reason. So again, very high level overview. We're going to break every component of this down. Starting with who is a covered employer. So an employer is any person engaged in commerce or in any industry affecting commerce who employs 50 or more employees for each working day during each of 20 or more calendar work weeks in the current or preceding calendar year. Now, as simple as that might sound, again, there are definitely more nuances to that definition. So to determine if an employer is covered by the FMLA, the employer may need to examine both the current and prior year's payroll. Now, this, again, this is a common misconception by employers, is that it's only for the current calendar year. But you can see from the definition here that you also have to examine the year prior. So you would have to potentially look at 2018 numbers as well. If you're kind of on that hump, you're hovering between 48 and 52 or somewhere in there, and you're not quite sure, you may need to also review the preceding calendar year in order to determine whether you're going to be covered by FMLA. So some things to keep in mind with regard to the question about who is a covered employer. So the 20 or more work week requirement does not need to be consecutive. So if a person is employed by a company and they've been within the last 7 years potentially, that consecutive time frame is not required. So it doesn't have to be 20 or more consecutive weeks of 50 employees. It has to be 20 or more work weeks in that year. So if for 1 month you meet the requirement, the next month you don't, but then the following month you do meet the 50 employee requirement, you're still going to be controlled by and have to comply with FMLA. So that 20 or more work week requirement does not need to be consecutive. I would also caution that you should not get hung up on that industry affecting commerce portion of the definition. And the reason being is that the regulations state that any employer that meets the 50 employee coverage test is deemed to be engaged in commerce or in an industry or activity affecting commerce. So don't get hung up on the affecting commerce or industry bit. If you have 50 employees, the regulations basically say that you are then engaged in commerce. So that's kind of a non-starter. Employers who fluctuate around 50 employees need to monitor FMLA coverage very carefully. And I've got an example here that I'm going to spell out. So remember how I talked about it is also, you also have to examine the previous year. So if an employer with a total of 50 employees, this is counting full-time, part-time, and temporary employees, mind you. So if an employer with a total of 50 employees on each working day in each calendar week beginning January 1st, 2016, and continuing through May 19th, 2017, will have met the 50 employee requirement and be covered by the FMLA beginning on May 20th. Now that's because they had 50 or more employees on each working day in 20 calendar weeks. So even if, so they are covered by FMLA on May 20th, 2016. Even if that employer's employee total falls below 50 on, say, May 21st, 2016, and doesn't again reach or exceed the 50 employee total for any of the remainder of 2016 or 2017, the employer continues to be covered by FMLA for all of the remainder of calendar year 2016 and all of calendar year 2017. So this isn't like turning on and off a switch where if you have 50 employees on one day, there's coverage, and then if you fall below the next day, the light switch gets turned off and nobody's covered. That's not how that works. So if you meet the requirements on that working day in each calendar week for that year, you reach it for not only 2016 or whatever year you happen to reach that in, but also the following year. So again, that's a very confusing thing for a lot of companies, but just do keep that in mind that if you're fluctuating around 50 employees, you're going to need to watch that coverage number very carefully. Whether a person is considered to be employed by an employer for purposes of that 50 employee count is very broad. I touched on that a little bit already, but whether a person is employed by an employer and is therefore an employee for purposes of FMLA means a person who is permitted or suffered to work. And so that comes from the Fair Labor Standards Act definition of who is an employee. So if an employee is permitted or suffered, probably suffered, but kidding, suffered to work, then they are considered to be an employee. So this applies to full-time, part-time, temporary, seasonal, anybody whose name appears on an employer's payroll during a work week is considered employed each working day of that week, whether the employee receives any compensation. So basically, the definition of who is an employee under the FMLA is very, very broad. One, again, little tiny caveat and little tiny exception here is if you have an employee who starts working after the first day of the calendar week, so Tuesday, or terminates employment prior to the last working day of the calendar week, Thursday, that employee is not counted because the employee has to be employed each working day of that particular week in order to be counted toward the 50. So if that makes sense, that's another kind of small minutia there. An employee that is on paid or unpaid leave is also going to be counted if the employer has a reasonable expectation that the employee is going to return to active employment. So, for example, if you have an employee that's out on FMLA, out on work comp leave, out on, if you have a voluntary sabbatical policy, for example, an employee that you think is going to be coming back to your company to work, they are going to be able to be counted toward that 50 employee count. Somebody requested to know whether the webinar will be available in a recording. Yes, we do record all of our presentations. However, you will not be able to get the HRCI credit if you do not attend the full webinar, but yes, it will be available in recording. Further, as far as who is considered an employee for purposes of a covered employer, FMLA only counts those employees that are employed within one of the states of the U.S., so the District of Columbia or any of our territories. So FMLA does not count any employee that's employed outside, you know, if you have a branch of employees working in Bulgaria, as an example, they are not going to be counted toward that 50 employee count for purposes of FMLA. And again, another issue to keep in mind about who is a covered employer is if a company has an ownership interest in one or more other companies, they may be considered one integrated employer. So if there's a relationship between two companies and they have a common management structure, if there's centralized control of the employees or common financial control, as an example, the companies are going to need to combine each company's number to determine whether they're going to meet 50 employee requirements. So if you've got X company with 30 employees and Y company with 30 employees, but there's common ownership, common management, all of those things, then together those companies would equal one, and with their 60 employees would meet the requirements to have to provide FMLA to their employees. One of the hot button topics that we are seeing come up a lot is in regards to joint employer coverage. Joint employer coverage isn't as much of a hot topic with FMLA, but it is an area that a lot of employers are getting tripped up in. There's a lot of nuance that goes into determining whether joint employment exists. I'm going to get somewhat into that, but not totally. Just again, it is a fact-intensive inquiry as to whether a joint employment relationship does exist. So the main points to sort of remember from this are that even if a company has fewer than 50 employees, they still may be covered because of a joint employment relationship. Now, this is different than what I was talking about before, where there's common ownership, common financial control, common management, all of that. That is a different situation. In that situation, we're talking about an integrated employer. In this situation, we're talking about joint employer coverage. So this would be some of the situations where joint employer and joint employment has been found to exist include an arrangement between two or more companies to share an employee's services, for example, like a co-op, for example, where two or more employees are not completely disassociated, but there might be joint control. So like a PEO, for example, a professional employer organization, or temporary employees that are placed by a temporary placement agency with the company. So their joint employment essentially exists where you've got two or more different entities that have separate buildings, owners, finances, separate everything. But one entity is benefiting from the work of another entity's employees during that work week. And the most common situations are with temporary staffing employees and then PEOs. So if joint employment relationships, if it does exist, then both companies have to count those jointly employed employees regardless of who maintains the payroll. The payroll is not going to be the key here. The key is really going to be who is essentially controlling and employing these particular individuals. So I do have a quick question here. I just want to look at it. One of the questions we have is, how would FMLA work for staffing companies since many do not work the amount of hours, and how far back do we go to that look back period? So you are going to have to look at how many, if you have 50 employees working in each work week of each work day of each of 20 work weeks, then you're going to hit that number. So I know for staffing, the tracking on that can seem daunting, but you'll just have to, be tracking that. It doesn't matter how many hours they work. It matters if they worked each day during that particular work week. So back to the joint employer coverage. With a PEO, when joint employment exists, both companies have to count those jointly employed employees. And so as an example, if an employer has 15 employees from a temporary placement agency, so from a staffing agency, and 40 of its own regular employees, they have to count all 55 employees toward that count, and then they would be covered by the FMLA. Now, this is, of course, presuming that those 15 temporary employees work for 20 or more calendar work weeks. But it is possible that if you have 15 employees placed with you that are working for 20 or more calendar weeks, and 40 of your own, that's going to push you over that 50 employee threshold and require that you provide FMLA coverage. All right, so switching gears from who is a covered employer to who is an eligible employee. So if the employer is a covered employer, meaning they have 50 or more employees in those 20 calendar work weeks, the next step to determine is whether the employee is eligible. So to be eligible for FMLA leave, the employee has to be employed by the employer for at least 12 months. So there's a period, a length of service requirement. They have to have worked for the company for 1 full year, 12 months. They need to have provided at least 1,250 hours of service during that 12-month period just prior to the date FMLA leave commences, and they must work at a site that has at least 50 employees or a site that has at least 50 employees within 75 miles. So I'm going to break down all of this, but essentially to determine if an employer or an employee is eligible, they need to have worked at least 12 months, have provided 1,250 hours of service during the 12 months just before the date FMLA commences, and work at a site with 50 or more employees within 75 miles. All right, more nitpicky things here about the 12 months of employment, because nothing can just be as easy as they need to have worked for 12 months. So the 12 months does not need to be consecutive. So if you recall, They just need to have been employed by the employer for at least 12 months. It doesn't have to be the previous 12 months. It doesn't have to be, consecutive time. If they are seasonal and they've been working for your company for 3 years and they worked 4 months, 4 months, and 4 months in each of the 3 previous years, that's 12 months, and so they're going to be covered by FMLA. And so the look back period, it doesn't go forever, so it can't just be a week here, a week there, and then the last 7 years it somehow adds up to 12. The look back period of time for employee eligibility is 7 years. So only the months of employment during the 7 years prior to the date leave is to begin have to be counted. So again, that 12 months needs to have been worked within the previous 7 years in order for them to qualify. Employment periods more than 7 years earlier, though, do need to be counted if the break in service occurred because of fulfilling National Guard or Reserve military duties. There is an exemption from that 7-year period of time for those serving in the National Guard or Reserves. Again, if an employee who is hired on an intermittent, occasional, casual basis, if they have 52 weeks of employment, that is equal to the required 12 months. So those employees that might be seasonal, for example, 52 weeks of employment is equal to the required 12 months. Again, if an employee is maintained on payroll for any part of a week when that employer provides benefits, whether they perform services or are on paid or unpaid leave, that week counts towards the 12 months of employment. So as long as they are getting either health insurance benefits, wages, what have you, if they're on paid or unpaid leave, those weeks are still going to count towards their requirement that they work for you for the last 12 months. Not the last 12 months, but work for you for 12 months. So just think about it as if they work for you for a total of 12 months in the last 7 years, that is going to meet this prong of the requirement. Just as kind of a little tip here, pro tip, an employer can give an employee approved time off of work before they become FMLA eligible. We have a lot of clients do this. They have a lot of sympathy for their client, or they're just, want to give their clients more benefits than what they're required to. So let's say that this company, you have an employee come to you, they are, maybe not yet employed by your company for the full 12 months, but you're going to let them go out in month 11 for a non-FMLA leave. If an employee is on that non-FMLA leave at the time that the employee meets the eligibility requirements, the time off that the employee takes before they are FMLA eligible is not considered FMLA leave. So again, let's say, it's month 11 and an employee has surgery and you allow them to go out on a leave that is not FMLA, obviously, but you allow them to go out on leave. And while they're on leave, they become eligible for FMLA. That entire month 11 is not considered FMLA leave. So in the event that the employee becomes eligible for FMLA leave while out on that non-FMLA leave, any part of the time that they take after they meet the eligibility requirements would be FMLA. So that month 11, that's not going to be FMLA, but month 12, once they are eligible and moving forward, that would all be designated as FMLA. So just kind of be aware there that in granting FMLA to somebody who's close to reaching the requirements of, being employed for 12 months, it is possible they would get the 12 weeks of FMLA time plus whatever non-FMLA time you granted them. You cannot count non-FMLA time against an employee who is not eligible for it. So a lot of companies try to be very generous with their employees, but just do know that that can increase the amount of time that that employee would be able to ultimately get leave for your company. Okay. So just I wanted to run through a quick example here because I think this is a very interesting case. So I have an employee that's been with us for 11 months, and they just came to me and requested FMLA leave. They're letting me know that on month 12, when they're going to be eligible, they're going to be starting FMLA leave. So can I let that employee go? And if you can't tell from the bear here, no, you cannot do that. Under the FMLA, one of the requirements, obviously, is that they have worked for at least 1 year. So what happened in this is from a particular case. A plaintiff, the employee, claimed that, she went to HR and told the HR that she was going to be taking FMLA once her 1 year was up and she was eligible. But the plaintiff, the employee, claimed that HR told her that she had to begin her leave immediately, even though there was no medical reason requiring her to do so. She was having surgery the following month. HR had encouraged the employee to move her surgery up to month 11, and then assured her she would get FMLA leave and her job would be protected and all of that. Except, you can already probably see the writings on the wall, except it wasn't. And the plaintiff, the employee, got fired instead. So she sued. And what happened was the court came back and said that, the company, they would have been okay as far as the FMLA was concerned if the employee had simply taken off for her surgery on her own prior to becoming eligible for FMLA. So rather than encouraging her to move her surgery up to when she didn't have job protected leave, if they just would have given her some time off for her surgery, that would have been fine, like I just talked about, and companies can do that. But because what the company did here was they had her, encouraged her to move it up, 6 days after she would have become eligible is when she was going to have the surgery. So she would have had job protected leave had she had the surgery when she was originally slated to have it. There was no medical reason for her to move the surgery up. The whole point of it was HR encouraged her to move her surgery so that they could let her go because she wouldn't be protected by the FMLA. So this is totally contrary to the concept of FMLA and allowing an employee to be able to use that. So if a company that fires an employee who requests FMLA leave before they are eligible can get sued. So do not fire that 11-month employee who just requested leave. That is going to probably get you sued. Got a question here. So the question is, I have an employee who is employed with us full-time from September 29th, 2014 until June 30th, 2017. She then terminated employment and had children, I guess, while she was out. She returned in May 2018, but did not work full-time until September 2018. Because of the break in employment, she would not be eligible for FMLA, correct? The company has already approved her leave. It just won't qualify for FMLA. Okay. So remember there are 3 prongs here to this test. So if the employee was employed full-time from 2014 until 2017, it's 2019, so she's clearly met that 12-month requirement to qualify for FMLA leave because of her employment. However, so let's see, she came back in May of 2018, but did not work full-time until September 2018 because of the break. So the other component you have to look at is in the year prior to when she asked for FMLA now. So if she asked for FMLA, for example, on April 1st, 2019, you have to look at, did she work 1,250 hours in the previous year? So she's going to meet that 12-month requirement, which is only one of the requirements The other thing she's going to have is 1,250 hours of service. So if she was full-time after September 2018, it's probably pretty likely that she's going to meet that 1,250 hour of service requirement. So she worked at least a total of 12 months in the past 7 years, so she's good there. Did she work the 1,250 hours of service? That would be your next assessment to make. I got a response. She did not have 1,250 hours. So then if she didn't have 1,250 hours, she doesn't meet the second prong to be eligible and therefore would not qualify for FMLA leave. Which is a great segue into the second prong of the employee eligibility test. So to determine whether an employee has worked the 1,250 hours, you use the FLSA, the Fair Labor Standards Act rules as far as what is compensable time. So any time that the Fair Labor Standards Act says is compensable is considered a working hour for purposes of going to that 1,250 hour requirement. So not to get too heavy into the FLSA here, but as an example, many states, California included, have waiting time requirements or donning and doffing requirements. So if you have an employee who has a complicated uniform, for example, that they have to put on when they arrive at your facility, that time putting on and taking off that uniform is considered compensable time. And so that would be considered time worked that goes to that 1,250 hour requirement. And obviously, the easiest way to be tracking this is through use of timesheets. So however you have, if it's a time clock, a timesheet, however that is done, you've got to track whether that employee worked 1,250 hours during the 12 months preceding the date that FMLA leave is to start. So the 12-month requirement can be in the last 7 years. The 1,250 hour of service requirement must be in the preceding 12 months. And this is the preceding 12 months from the date that FMLA is to start, not the date that it's requested. Okay? So just kind of keep that component straight, that the 1,250 hours worked must be during the 12 months preceding the date that FMLA leave is to start. Obviously, for non-exempt employees, you're not probably requiring them to keep track of their hours. And I'm sorry to say, it's the unfortunate burden of being an employer, but it is actually the employer's burden to prove that an employee who is exempt did not work the required 1,250 hours. So if you have an exempt employee that is not tracking their time because they're salaried and you don't track it, if you're going to try to deny that employee FMLA leave because you're saying they didn't work the required 1,250 hours, you better be ready to prove that that employee didn't work those hours. And that can be very tricky. A lot of times, for a lot of different reasons under the law, we, employment lawyers, recommend timekeeping even for exempt employees. And now your exempt employee is probably likely to just write down 40. And that's fine, but at least you have some type of proof as to how many hours they worked if you're going to try to deny eligibility. So this question, if they meet the eligibility requirements, how much time do we allow them to return the paperwork back to the employer? Again, this is something that we're going to be getting into in another presentation, because there are many different notice requirements that an employer is required to comply with. But essentially, this is going to depend on whether you need certification, because a certification, an employee has I believe it's 15 days to provide you with a certification of their need for FMLA under, for the 15 calendar days if it's for a serious health condition. But there's many other types of notice requirements as far as the notice of eligibility and rights, which has to be provided within 5 days of knowing that a type of leave may be FMLA qualifying. The company then has to provide notice designating leave as FMLA qualifying. Again, that is within 5 days of knowing that the leave does qualify. So again, all of those are things we will be getting into in a subsequent presentation, but there are very strict timelines as far as when the paperwork has to be returned to the company. I have another question here I'm just reading through quickly. Okay, so here's the question. This is a follow-up question. So this is regarding the employee who worked for 3 years, left the company, came back, and apparently now is having another child. So the person is saying the board has approved her to be gone for maternity leave. Does it really matter? They have no intention of not continuing her position, so it's going to be job protected. And then they say, if I were to figure her hours through the date she actually leaves for leave, she would probably have 1,250 hours. It does matter because failing to designate leave as FMLA qualifying when it does qualify as FMLA is considered FMLA interference, and that's a lawsuit that employee would be able to bring against your company, because going out on federally protected, job protected leave where you're required to maintain her benefits and do all of those types of things, if an employee meets the 12 months of service, meets the 1,250 or 12 months of employment, 1,250 hours of service, and there's a qualifying leave, which is of course to have a baby in this instance, if she qualifies for FMLA, it must be designated as FMLA. You can't just say, well, it's maternity leave, we're going to protect her job, so we don't have to designate it as FMLA. You have to. Failure to do that, again, constitutes FMLA interference and would be subjecting your company to a lawsuit. Okay. So again, as far as tracking exempt employees' time, highly recommended for a number of reasons, least of which is to determine 1,250 hours of service. But we're going to get into this later, intermittent leave is going to be a bear all on its own. For exempt employees who are not tracking their time and are used to sort of coming and going as they please, if an exempt employee is taking intermittent leave where maybe they're working 4 hours a day, 3 times a week for the next however many months, you have to be able to track that intermittent leave, and getting exempt employees used to tracking their hours, while weird and not required by the law, of course, is still a good practice to get in the habit of. Okay, the third part of the test here that we're going over today anyway is the requirement to have 50 employees at the work site or 50 employees at a work site within 75 miles. Again, almost all of the parts of FMLA just seem so simple until you start digging into the nuts and bolts of it. So some of the things to remember here are, whether the employer employs 50 employees at or within 75 miles of the employee's worksite has to be determined when the employee gives notice of the need for FMLA. So this question that I was answering for one of our attendees here, you start counting those 1,250 hours of service on the date that the employee's leave is set to start. So 1,250 hours as of the date that FMLA leave is to start. Now here you've got the requirement to find out if you have 50 or more employees within 75 miles when the employee gives notice of the need for FMLA. Totally different rule here, right? So if once an employee is giving you notice of the need, so they've come to your office and they said, I'm going to have a baby, I'm going to need FMLA leave in 3 months. Well, you've got to count that employee count on the date that they give notice of leave. I have an example here. If an employee's worksite has 60 employees in August, when the employee gives notice of the need to take FMLA parenting leave beginning in December, so several months down the road, the third eligibility requirement, the 50 employees within 75 miles, is met whether or not the employee's worksite drops below the 50 employee total before December. So in August, when she gives notice that leave is going to start in December, there's 60 employees. Well, if in October it falls to 30 employees, it does not matter. The 50 employees within 75 miles is going to be met because there were 60 employees in August when she gave notice that she would be needing FMLA leave in December. So again, these rules seem simple, but you get into the nitty-gritty and they get a little bit more complicated here. And this is true whether leave is taken in one block of time or intermittently. So the 50 employees within 75 miles on the date of notice, even if it's intermittent leave, so let's say it's not to have a baby, but they give notice in August that they're going to have surgery on their back, and they're going to be out for 3 weeks because of that, and then they'll be gone 2 days a week for every week for the next, 5 months or something like that. Please don't check my math. I don't know how many weeks that is, but let's just say, it's going to be intermittent. Still on the day that notice is given is when you count the 50 employees. The work site, also, this becomes complicated. So 50 employees at a work site or within 75 miles. So the work site is generally the location where the employee reports to work. Most people, although this is changing now with working from home, telecommuting, most people still report to a work office. So in my situation here at my firm, I'm sitting at my desk in my office building in Minneapolis. There are more than 50 employees in my actual building, so my law firm has to comply with FMLA because there are 50 more employees right here. Now, if we had a branch, as we do, we have a branch in Milwaukee, Wisconsin. It's definitely further than 75 miles away. So if we had, 30 employees here and 30 employees there, then we need to look at, okay, so there's 30 employees in Minneapolis and there's 30 employees in Milwaukee, and that's more than 75 miles apart. But who is actually giving out these assignments? So this, you can see how this becomes complicated, because if the work site is a remote work site, or they're working from a home office, or there's no work site in the case of construction workers, transportation workers, those sorts of things, you have to look at where the employee's work is assigned from. So in the case of our law firm, if the lawyers here in Minneapolis are just assigning the employees in Milwaukee work all of the time, and they're not generating their own necessarily, but they're sort of taking orders from the lawyers here in Minneapolis, well then that 30 employees in Milwaukee is probably going to equal 60 here because they're really getting their assignments and work assigned from here. Now that's not the case in our company, but in some companies that would be the case. Again, if the work site is the employee's home, if they're working from home, wherever they're reporting to or wherever assignments are made from, that is going to be the employee's work site. So even if that work site is more than 75 miles away, if they're meeting that test for where things are assigned, work is assigned from, or where they report to, that is going to be the work site for purposes of counting the 50 employees within that 75-mile radius. Then you get real tricky here because 75 miles, the way that it is measured is confusing. So 75 miles is measured by surface miles using transportation over public streets, roads, highways, and waterways, using the shortest route from the facility where the employee needing leave is employed. That's a lot. That's a mouthful there. But suffice it to say that the reason that we've had to spell out how specific to measure 75 miles is because at some point somebody said, hey, we're actually 75.2 miles away, and so therefore you don't meet the requirements for FMLA. And so now a regulation has had to come out with how you actually measure the surface miles between two different branch locations. Again, I know this sounds crazy, but there's a warning label for a reason, right? Somebody tried to say we're 75.2 miles away, therefore we don't have to offer that. So again, this is it's a crazy, complicated issue, but you know, if you think you're within 75 miles, maybe just go the route of giving the leave if you're that close. All right, no more questions that I see. Posting and record keeping, this is a fairly straightforward topic, but it is something I want to cover just so everybody is kind of aware. But every employer that's covered by FMLA, so that every employer that has 50 or more employees in 20 or more calendar weeks, is required to post and keep posted a notice explaining FMLA's provisions and information on how to file complaints. So this is very straightforward. It's very easy to fulfill this requirement because employers can simply take the text of the notice that's published on the Wage and Hour Division's website, print that out, and you're good to go. As long as it's legible and it's large enough print and all of those types of sort of nitpicky things, as long as it's legible, that is going to cover your workplace posting. Now, where to post this becomes a little bit more complicated because, of course, the regulations say it has to be posted where notices to employees and applicants are customarily posted. Well, when you bring in an applicant, maybe they come past your front desk and maybe they walk directly into a conference room. And is there any chance for them to see your poster in your break room if that's the case? Probably not. So what we do is we distribute our FMLA posting in the materials with to an applicant as far as, you know, how to get to our work, how to get here for their interview, what the position is for, all of those things. We post that in that way. But you do have to make sure that the post can be seen by your applicants in addition to your employees. So most of the time, this is going to be something that's posted in a break room. If you have remote employees that are not always there to be able to read this, electronic posting is permissible, but remember that it does have to comply with all of the other requirements, which means the electronic posting has to be accessible to your applicants. And that's how we provide the posting, again, to our applicants is through electronic means. If you have a significant portion of your workers that are not literate in English, the employer has to then provide the notice in a language in which the employees are literate. So luckily, there is a copy of the FMLA poster in Spanish on the Wage and Hour Division's website. However, employers that have large populations of Hmong or Somali, as we do here in Minneapolis, need to typically go through a private source to be able to get posters that are in those languages. And just so you know, if you are a covered employer, you have to provide this notice whether you have eligible employees or not. Okay, employee handbooks. So you have to provide the notice, the general notice, even if you don't have eligible employees. If you have eligible employees and you provide a handbook or other sort of written guidance, then you must also include written FMLA notice in your handbook. So if you have an employee that is eligible for FMLA and you give out a handbook, then it should be in the employee handbook. One thing you need to make sure that your policy includes at a minimum is to specify the 12-month period. I can't stress this enough. Employers should define the 12-month period over which employees may use their 12 weeks of FMLA, because you get 12 weeks of time to use for FMLA, but you can only use 12 weeks in a 12-month period of time. And so the chosen method should be specified and applied across the board. If it is not, then the employer may end up having to apply whichever option provides the most beneficial outcome for the employee. And just a quick overview of that, but your options for how you set up your 12-month period, you can use a calendar year, you can use any other fixed 12-month period like a fiscal year, and then there's two rolling options. You can use a 12-month period measured forward from the date of any employee's first FMLA leave begins. So if they're going to start FMLA April 1st, 2019, they have to use 12 weeks by April 1st, 2020. The other option is to do a 12-month period measured backward from the date an employee uses any FMLA leave. So I recommend using one of the rolling options. It prevents stacking. So if you have a calendar year and you have your employee use all 12 weeks at the end of, let's say, 2019, and you just use a calendar year, technically they're going to be able to use their 12 weeks starting on January 1st, 2020. So you could end up with an employee taking 24 consecutive weeks of job-protected FMLA if you use a calendar year method. So we don't recommend that, but you should specify that. You should also talk about whether an employee has to use any of their other paid time off concurrently with FMLA. You should definitely put in there how an employee provides notice about their need for the leave, or how they provide notice. If it's intermittent leave, how do they call in? If you're going to require fitness for duty certification in order to return, it's very wise to include that in the handbook. You should include the increment of time in which FMLA leave can be taken. It cannot be any time greater than an hour. So you can't require an employee to take FMLA leave in like 4-hour chunks. You can only require it in at least an hour or less. Let's see. Here's a question. Not sure if this will be covered. Can an employee choose if they want to use their leave, sick or vacation, before taking FMLA if they're having a baby? What if the employee and employee agree to that? So you're saying, what if they want to use up their sick or vacation leave before FMLA? They can't. There's actually a very recent, this is a great question, because there's actually a very recent case that came out that said that you can't do that. If they qualify, it is not up to the employee to say, well, wait, let's hold off on FMLA. I'm going to use up my sick time, and then I'll start that. That is not something that an employer and employee can come to an agreement on. There's recent case law that actually came out on that. If it's not okay, how do we correct that? Just, I would say don't do that going forward, and have them use their paid time off concurrent with FMLA. So if they qualify for, they're going to have 5 weeks of FMLA and they've got 3 weeks of paid time off banked up, they get 5 weeks of FMLA and 3 weeks of it will be paid. So the other thing I would recommend specifying is things that protect the employee or protect the company against employee abuse of FMLA. So, for example, consider implementing a policy that if an employee accepts or continues other employment while out on FMLA leave, that if they apply for unemployment, for example, that may be treated as a voluntary resignation. So just keep that in mind as far as your employee handbook. We're kind of running out of time here, but I do want to just quickly get through this. I apologize if anybody has a hard stop at noon. I do want to just finish these couple of things up. As far as record keeping goes, there are many requirements about what an employer has to keep as far as records regarding FMLA. So those records include payroll information, identifying information about the employee like name, address, occupation. You have to keep track of all of the leave dates, all of the hours that are taken, the leave requests, how you responded to those requests, your policy information, so your handbook, any insurance premium payments that you made while the employee was out on FMLA, and then if there's any disputes about FMLA or the leave, keeping track of that. And then employers also do have a duty to preserve medical records. So if you're seeking out medical certification from an employee to justify the need for leave, you've got to maintain those medical records that are associated with the leave. But please remember, medical records, all medical records, whether they relate to FMLA or not, must be kept in a separate file from other personnel records. So you cannot keep medical records of any stripe, including FMLA medical, in the same personnel file as all the other information. That's got to be kept separate. And it also has to be, you have to also ensure that you are keeping that information confidential. And then certifications regarding leave taken under military family leave provisions also have to be kept separately. So if you're requesting that a family member provide proof that they will be attending a military service member's homecoming, that certification, or that they are going to be attending Walter Reed to care for a injured service member's injury, and you're getting certification for that, that has to be kept separate as well. So again, just a couple of nuances with regard to preserving medical records. And it looks like I've got, let's see, a couple of other questions. Can a company store documents in an HRIS with separate document types? For example, FMLA may be uploaded with a type of medical but would be housed in the same system as other information like resumes. You know, it's going to probably depend on the HRIS system, but as long as you are storing things separately, and you know, one thing to keep in mind with medical records is the confidential nature of medical records. You would want to make sure, for example, if you are going to use an HRIS system and be housing these records electronically, maybe consider separate password protection on that type of file so that only those with a need to access the medical records can. That would kind of show a way of segregating the records from the rest of the personnel file. But because you can store records electronically, there will be, in most HRIS systems, a mechanism for creating separate files. I just recommend password protection on medical records as not only a way to maintain the separateness, but also to maintain confidentiality to those who have a need to know. Somebody has asked if we have to leave the presentation now, can we get credit? Absolutely. We're just in question and answer. Permissions are given to those who need to see them. Yeah, I mean, if that's the case, I mean, I don't know. I can't really assess the system and whether it's going to qualify as separate. I mean, suffice it to say that as long as they are somehow separated in an electronic system, that is perfectly okay. They just need to be, you know, they do need to be segregated apart from the rest of the personnel files. So whether that's in a separate password protected folder, a separate a folder that has different permissions, that's separate, that is all okay. Okay, I do apologize that we went so long. I will hang out here for a couple more minutes if anybody else has any questions. Again, I apologize. FMLA is a very complicated subject, so the details are very picky. So I like to make sure that people are aware of, as simple as the test for who qualifies for FMLA may seem, you can again get into the weeds on those things. So any other questions, please let me know. And please do take the survey if you have some time. It really helps us. And, if there's a topic that's kind of something that you've been really wanting to hear about, this is how I'm kind of picking these topics right now. So let us know what you think. Any other takers for questions before I end this? Okay, let's see, got one. Would you please repeat what I can do in terms of maintaining records for the employees who used sick/vacation before FMLA leave? I mean, at this point, it's not the right way to do things, and so you're just going to have to keep the records as they are. You can't go back and doctor them up to make it seem like the FMLA was designated on time. So you'll just have to keep the records and just modify the practice going forward, knowing now that you can't, that is not something that can be done. And honestly, we don't recommend doing that anyway, because if somebody has a month of vacation or sick time banked up and then uses FMLA, in addition to the 12 weeks they get for FMLA, they're going to use all of their paid time off as well. So, I understand that employers try to be very generous to their employees, but that's that from an operational standpoint can become an issue if you've got to already accommodate 12 weeks of being out, and now you're adding on however much time they might have under their accrued sick, vacation, or PTO. So, I just, at this point, you'll just have to keep the records as they are, maintain those, maintain the FMLA required records as well, and just move forward knowing that that's not the right way to do it, unfortunately. This is again on the file segregation, and I wish I could give you more information about whether that's going to qualify as being physically separate. I'd have to see the system, and unfortunately, without seeing how it's set up or what it looks like, I mean, if it's a separate it's got its own file type and only certain people are having access, I mean, I think you're probably close, or you're doing really well on it, but without actually physically looking at it, it would be hard for me to tell. I suspect that any HRI system, Aviante. I suspect that Aviante is very knowledgeable about the requirement to preserve records separately from others. So again, I'm not going to be able to give you a definitive answer about whether that is going to be appropriate or sufficient to qualify as keeping the files physically separate without actually looking at the system itself. So if you're a client of ours, definitely, you could open up a ticket and ask us to look at that for you, and we could assess whether we feel like it meets the requirements under FMLA. Okay. All right. Well, I think that's about all we have for questions. If there are any other questions and you don't want to talk about them on here, feel free to reach out to me directly. You can reach out to info@myHRcounsel.com. If you're a client, open a ticket. Otherwise, thank you so much, and thank you for hanging in a couple of extra minutes here. I know everybody's time is very valuable. So have a great day. I hope that you can all join us for the second part of our FMLA presentation. Have a great day. Bye-bye.